Good morning, everybody. It's Stephen Williams, founder and president of the creditrepairshop.com. And in today's video, we're going to talk about court summons. I get a lot of questions on these. We help our clients with these. I give information on what you could do if you are dealing with a court summons, because with the way that these debt collection companies are buying debts and also the strategy that the original creditors are using, they are suing people left and right. They're changing laws left and right that will allow them to arrest people that don't show up to court hearings or that don't respond to court summons. It's just unbelievable. The states of notice that are actually applying this is Michigan and also Minnesota. Other states are, signing on to it. Now, just so you know, in all 50 states, it is legal to arrest someone who does not show up to court. It's just like if you have a warrant for your arrest because you haven't paid tickets, speeding tickets, same thing can happen for debt. But the only thing is that because debt is it's a civil action, a lot of law enforcement organizations didn't really enforce those. Well, what's been happening in some states is that the debt collection companies are saying they want it enforced. They want that individual to have to come to court and tell us how they're going to pay the debt back. So this whole video is going to, number one, help avoid that if you have debt collectors coming after you and they start to sue you and you get a court summons. So first, what is a court summons? A court summons is where if you have a debt with a debt collector or the original creditor that you owe money to, or just anyone that you owe money to, what they have to do is they have to file paperwork at the courthouse, and they fill it out, and that's called a summons to make you come to court to answer to the debt. What gets it to that point when it comes to debt collections, to old debts, is that when people received a letter in the mail, they didn't respond. You must respond to that, or you are actually allowing them to go to the next step, which is to put it on your credit reports and to put a court summons. To get a court summons, they'll pay a fee to the courts, and it'll either be small claims courts or it'll be a large money judgment court, which is usually $5,000 or more. So what they do is they'll fill out all of this information about about you and the particular debt. And when you get that court summons, it's usually served by a sheriff or sometimes there's just people that are paid that are servicers. They'll just try to hunt you down, go to your last address, and make you sign for the summons to let you know that you're being sued. And so when that happens, which in a lot of cases that don't even happen, they just have to prove that they tried to service you. And a lot of them are just allowing it to be mailed, and if it's mailed to your last address and you get it, that's good enough for them now also. It just depends on your state. But when you get the summons, and the first thing you need to do is don't panic. Don't panic. You're talking to a person that has had a summons, that has went through exactly a court proceeding, and I'm going to tell you from my own personal experience. So this is not theory. I'm not some punk kid on YouTube that's just telling you theories about stuff on what to do. I'm telling you what I personally went through and what my clients have went through. So this is 100% fact. 100% fact. I know there's a lot of fake stuff out there, but this is 100% fact. So what I want you to do is to turn off any other stuff that you have and listen to me, because this is real deal facts if you're dealing with a court summons. So now the first thing that I always tell people to do, and I wish someone could have told me at that time, because I panicked, but I didn't panic. I'm telling you, don't panic, because it's not the end of the world. There's solutions. and I'm going to take you through all the potential solutions. So don't panic. Calm down. Tell the wife and kids, or tell your spouse or whoever, your girlfriend, boyfriend, whoever. Calm down. It's not the end of the world. There's a light at the end of the tunnel. I'm going to give you that solution. So now, the first thing you have to look at is, who is the originator of the debt? Is it a debt collection company that's suing you for the original creditor, where this is where they're assigned the debt, they've just been hired by the attorney, or are they saying that they own the debt? If they say they own the debt, then the next steps that you have to take is you have to validate the debt with them. This will be easier if they purchase the debt, because you can actually back them into a corner. And if you watched my other videos, I talk about this. If a debt collection company purchased a debt, they sent out the letter, you disregarded it, they got a summons taking you to court saying that you owe this debt, you still have time to validate it, but you have to do it a different way. Rather than with bureaus, you had to validate the debt with them, and you had to tell the court that you're validating it. But also, you have to answer the summons. That's where a lot of people get things wrong. And when I got my summons, in a way, I don't know what made me do it, but I answered the questions in the summons. It was like, maybe I just read it closely, and it was like, you owe this debt. Is this your address? It was like 8 questions in the summons. I answered them one by one. And that's what you have to do. So you have to actually answer those questions, and then you have to do a validation request to the debt collector, and you have to supply all of the information to the judge, which is the clerk for the judge, and you have to also supply that to the debt collector. When you do that, I'm telling you, it opens up a can of worms that debt collectors don't want to deal with. I've seen it where, when you know what you're doing, when I did it, I didn't really know what I was doing. I was just, answering the questions and just trying to figure out what this whole thing was about, because it was a debt that was from years ago. It was actually past the statute of limitations, and that's why you want to validate the debt. So with my own personal experience, I answered all the questions, and I said, I remember the debt, but I don't remember it being that high. They said it was $2,500. No, they said it was $4,500. And it was a debt from 1989, and I was like, there's no way that when I was 19 years old someone gave me that amount of credit. But I just answered the questions, and then I got into court, and I wanted validation of the debt. When I asked for the validation of the debt, they sent a stack of blacked out credit cards that they purchased, debt that they purchased, and they just left mine there by itself. And when I found that out, it was like, this is crazy, because they purchased all of this, all of these people's debt, but I still didn't put it together in my mind that they bought it for pennies on the dollar. I was just still focusing on, how am I going to get out of paying this debt, or the lowest amount that I could pay this debt. And but before we even get to that, is when you're validating the debt, you need to see if it's past statute of limitations. Because if I would have been paying attention, or if I would have knew, it wasn't paying attention because I didn't know that debt was past the legal statute of limitations for any state in the United States. It was, I think, probably 6 or 7 years past the statute of limitations for collecting that debt. They had purchased it, sold it to them. They purchased it from the original creditor, which was Citibank, and then they came after me for the debt, and it was way past the statute of limitations. They were just a debt buyer, and they were just trying to strike, digging to strike gold. But so that's the first thing you got to look for: is it past the statute of limitations? If they're taking you to court They don't have a judgment. That means that everything carries over with the regular contract law statute of limitations for your state. If they already had a judgment, which is way down the road, then those can last for 20 years. But for this one, if it's so, that's the first thing you should look at, is you're answering the questions, because you don't want to lose on the technicality. And then you look to see if it's past the statute of limitations. So you're sending that to them. And then you're doing your own research to see, when was this debt actually originated? When did it get charged off? Because then that's where it goes for the statute of limitations, is from that charge off date. Now, if it's not past the statute of limitations, and your next thing that you need to do is you need to do an evaluation of yourself financially. I just had a young lady that I helped that was being sued, and I said, well, what is your financial situation? Because I know what debt collectors look for. They look for, can they collect the money from an individual if they take you to court? Because they don't want to spend money after no possibility of getting money. And they look to do this the easiest way. They're very lazy in certain aspects of collecting debt. It's more about making phone calls, looking at credit reports, and trying to make some type of formulation to see if they could get the money from you. And they're basically looking at your job. But if you are unemployed, or you're disabled, something happened medically, something financially in your family has happened, your credit reports are not going to tell them that. So what you need to do is, if you have financial hardships that you can prove to them, that can make this whole summons go away. Especially if they've are assigned the debt from the original creditor. They'll just send it back, because they're like, this is not going to be, the well is dry, there's no money here to be collected. They'll just send it back, which is what happened with the client. She wasn't even a client, so she just watched the video on YouTube, and I gave her information on what to do. So if you are unemployed, disabled, or have some type of provable financial hardship, and regardless if it's a purchased debt by a debt collector, or they're assigned by the original creditor, hired by the original creditor to sue you for the money, you notify them of that, and you need to call them up by phone, and then you need to notify them. Listen to what they say. Listen to them. This call is not about how you're going to pay the debt. It's just to notify them of your financial situation, that you're either disabled, have a financial hardship, you're unemployed. They'll tell you what they're going to do with the debt. If it's assigned, they're going to most likely say, well, we're going to send it back to the original creditor. Even if they say that, which was the case with this particular person that I'm talking about, you still have to send all the information, answer the questions to the court. You need to send it to the debt collector, and you need to show up on your court date. When you show up on your court date, if they've said that they're going to send it back, or they're not going to sue you, they'll most likely say, when they call your name, they're going to say that they dismissed the case. If they don't, be prepared to talk to the judge about what they had said over the phone about not going after you due to the hardship or your disability. Now, let's move forward. Let's say that you have a job. You have, I don't want to say lots of money, but you have a job and you are able to be garnished. Everything moves forward. They checked all the boxes. This debt is not past statute of limitations. You're not disabled. You don't have a financial hardship, but you might be struggling financially, but they're not in the court's eye or the debt collector's eye that you're struggling. The next step is that you're going to when you go to court, you had all your answers. They're going to read them off. And then what you're going to need to do is you're going to need to ask the court or argue your side in court that, and this is basically to buy you time, and to maybe get the debt collector into a mindset of wanting to settle this debt because you're going to make them aware that you believe that the balances are incorrect and that there's problems with the account. So you're not saying that the account isn't yours. What you're saying is that there's potential problems with what you're seeing with the balances, with the amount owed, and some charges that were never proven to you. So you're going to ask the judge that you want more documentation to prove that this balance is yours, and they will do it. So you'll say, I don't believe that. I don't believe that. I don't remember the balance being this high. I want proof of all of the charges. I want my signatures because I do not recall any of these charges being this high. And they will do it. And then you can also say that if you were divorced or something had happened between you and your spouse, you could say that I did not have control of that card. We were divorced, something that, things had happened, and I want to see what was done from that other individual. You can also state that you believe that there's payments that were not credited. Like, there's a lot of things that you could do, and you could be creative. It's all about pointing out problems with the original record, because when they're taking you to court, they're stating their case and saying that you owe the debt. So what you have to do is you have to state your case on if you that you don't believe that everything that they are saying is proper. And then what the judge does is they say, okay, let's not go off of your word or their word. Let's just get the documentations here in the court. What that does is it backs the debt collection company up and original creditors, because they don't want to pay an attorney to keep coming back to court. What it usually does is it'll back them into a corner to want to get into a settlement phase for the account, because it just does. I mean, it happened with me. It's happened with many of my other clients. They're going to want to say, let's try to work this out. And usually the judge is going to say that they want to try to work something. They want you to work something out. They don't want to see you in court again. So what you could do, if you could argue this stuff, and then they're not going to have it in court. So what you could do next is you could say to the judge, can I have a minute with the attorney, the plaintiff attorney? They'll let you go into a room on the side and see if you can work something out according to what you're able to afford to do. Always start very low. Always start very low and let them come up. So when I say very low, if you owe them $10,000, you start at $500, because you can start at $200. Whatever you feel you want to come out at, because they buy these debts for pennies on the dollar. And the original creditor, they sell your information to other companies. If it's a credit card company, they've made thousands of dollars selling your name to different providers of services, with shoe companies, with insurance companies, all types of other products and services. They sell your data to them, allowing them to advertise you. So they've made the money. So you might as well start very low. Don't have any shame in doing that. And then let them come back with a counter. And if it doesn't come with what you're comfortable with doing, go back into court. Tell the judge that you were not able to come to an agreement and that you would still like all of that documentation, and then you can ask for a later court date. 9 times out of 10, debt collector is going to want to either settle then, or they're going to call you later and want to settle later. They'll usually try to say, well, let's do payments. Tell them that your financial situation doesn't allow you to do payments, that you're going to borrow the money from someone or whatever. You're going to do something to come up with the money, and you want to do it in a one lump sum. If it comes down to it, and you have to make a payment arrangement, it's better to do it and not allow them to garnish your pay. That's just a better situation to be in, because you can dictate the terms on what you're able to afford to pay. But everything needs to be done in writing. Nothing needs to be done with just words. Now, if nothing is agreed on, and you have to go and they uh, say, well, we just can't agree. The judge is on their side. You got one of these rotten judges that's just like, I'm gonna just let the debt collectors run all over you. You may see that you're the next phase, if you lose the court case and they do a judgment, they get a judgment against you. The next thing that they're going to do is they're going to try to garnish your wages. And when they move to garnish your wages, the next thing that you need to be prepared to do is to answer the garnishment worksheet and to look at the garnishment laws. They call it poverty guidelines in my state of Wisconsin, but in different states they call it something different. But there is a federal guideline for garnishing wages, and there's a state guideline for garnishing wages, and that means that if you have dependents and you earn under a certain amount of money, you may not even be able to be garnished. And so if you fall under that, then you need to notify the debt collector that you can't be garnished according to the guidelines of your state. And that's like a punch in the face when you do that to them, because it's like, oh man, we spent all of this money, we did all of this work, and this individual did something that 99.999% of the people don't do, which is to learn if they are even able to be garnished legally. We've stopped so many garnishments just by using that statute in the law, because and people just don't know about it. Debt collectors are not going to tell you about it. They're just going to push you through court. Even the judge in the court is not going to tell you about it. But when you're going to be garnished, there is a little worksheet that they give you, and even on that worksheet is so confusing to so many people that they just start filling it out, and it's like it's this times this, that divided by that, and this equals out what you're allowed to be garnished. And people like, I had problems in math in school, and you expect me to sit here and figure this out? I need to go to work and take care of these kids, so they don't even finish the worksheet. So but they never provide you with the garnishment laws on them to say that if you, and it's very simple in our state, it just says if you have this many dependents and you earn this amount per week or bi-weekly, if it's counting the dependents, they deduct the amount out of it because they consider that you need it for living expenses. They're going to not allow you to be garnished. And so that's like, we've stopped so many by just doing that, by just knowing that law. So many garnishments were stopped. So if you have any questions, number one, please subscribe to my page and tell more people about it. We help people, and I'm making more and more videos and going into more and more details about how to fix your credit, get out of debt, deal with things like this with court summons, deal with debt collectors. So if you need any, if you have any questions or comments, just post them below. Maybe no question is a stupid question. No question is a stupid question. So please post it below, and I'll answer it for you. And and then the next thing is just have a great day, and just don't get depressed when you if you find yourself in a situation getting a court summons. Thank you. This is Stephen Williams, founder and president of the CreditRepairShop.com.